Excuse me, Judge. Judge is inaudible.
Don't cut the video running like you. I must show every difficulty, every minute, every second.
Can you hear me now? I can hear, Judge. Thank you. That's much better.
I can hear his lordship.
Thank you, Judge. Thank you. I'd like to see the parties.
As it pleases the court, my lord, I appear on behalf of the plaintiff as per the record of court, and I am Lieutenant Commander Sylvester Volane Madala Mangolele, my lord.
Thank you, Mr. Mangolele. Please turn on. Mr. Mangolele, please do turn on your video.
My video is on, my lord. The only next thing that one can do is to, for the purpose of this, turn it off and then turn it on again, my lord, as the court pleases.
That is in order.
It is off now, my lord, and then there it comes and returns. As it pleases the court, my lord.
Wonderful. Thank you. Good morning, Mr. Mangolele.
Good morning, my lord.
Thank you. What brings us here today? You have invited us here today.
What brings you here today, my lord, is the relief sought by the plaintiff for the matter to be enrolled in terms of Section 18 of the Superior Courts Act. And the first prayer that the plaintiff prays for is for the matter to be enrolled as an urgent action in terms of Rule 612, and that the order or judgment issued on Thursday, the 12th day of September 2024, by the Honorable Morgan A.J. be set aside, for it is unconstitutional, unlawful, or invalid, and that payment of the sum and interest of the sum of 4,949,582 rands and 99 cents be, inclusive of tax, be paid to the plaintiff and the cost of suit, my lord. The prayers are in terms of page...
Mr. Mangolele, let's start here. First things first. Are you an attorney or an advocate?
My lord, I am a security services of the Republic. I am national security, a peace officer, and a justice of peace, as per the locus standi, notwithstanding that original locus standi inherit as a citizen of the Republic with the duty and responsibilities of citizenship as founded at Section 3 of the Constitution, my lord.
Okay. And then coming back to answering my question, are you an attorney or an advocate?
As I have said, my lord, I am neither that the court has averred. I am national security, a peace officer. I am basically, in terms of Section 200 of the Constitution, my lord. That is my fundamental statutory framework in this particular proceedings, my lord.
Okay. And are you here representing yourself?
I am here representing the plaintiff, which is a juristic person in terms of its name, Benja Enterprise, as alluded in the summons at page 1, indicating who is basically placing these particular proceedings before the court, my lord. So I am in service and
Mr.
I am in
Mangolele,
defense.
I hear that you are very eloquent and you have Constitution.
The
I
Constitution.
am assuming that, like most of us, you are a law-abiding citizen.
As it pleases the court. The reality is that
Mr. Mamalele, in what capacity are you representing the plaintiff?
in the capacity enshrined at Section 38 of the Constitution, my Lord, and Section 41 of the Consumer Protection Act, delineating that any person or anyone may represent another person who cannot act on their own name, or any person acting in the interest of a group or other people as envisaged in that particular reality at Section 38 and vehemently at Section 41 of the Consumer Protection Act, my Lord. The reality of these proceedings, His Lordship would understand the applicable principles at Section 2C of the Defence Act, obligating all members of the Defence Force to function in accordance with the Constitution. And His Lordship would understand that...
yes, are you a member of the Defence Force?
Correct, my Lord.
Are you a member of the SANDF?
Correct, my Lord.
Okay, do you appear in that court?
I appear in any court as called for service and defense of any person in the country as I have pledged. So whichever court of record that is available in our republic, which is my primary object to protect and defend, I appear in that any other court, my Lord.
Wonderful. We are blessed to have people like yourself who owe their allegiance to this country and the Constitution.
As obligated in terms of Section 41(1)(d) of the Constitution, my Lord, in our cooperative governance, all of us are obligated to be loyal to the Constitution first, then the Republic and its people.
Okay. Do you have the right of appearance at the High Court?
Yes, my Lord. That is in terms of Section 200 of the Constitution, my Lord.
All right. I will tell you what. Please forward that to the registrar. I will have a look at it so that I satisfy myself that you do indeed have the right of appearance at the High Court.
If His Lordship would take into consideration the applicable terms at item number 20 of the index in page 48 to page 52, that is the confirmatory affidavit by the natural person running the enterprise of this juristic plaintiff that is represented before the court, appointing me to appear on his behalf, my Lord. Other than that is the issue of us having to debate whether Section 200 exists or it does not exist, and any other applicable law surrounding the all applicable terms at Section 200 of the Constitution be applied and then be enforced accordingly. For His Lordship would call his library to the applicable terms at Section 237 of the Constitution, obligating that all constitutional obligations must be performed diligently and without delay. I see we are under technological attack. I don't know if anybody on record of court can hear me, or if anybody can be in a position where they aver or advance a term indicating their presence on record. Oh, it's my network. But it can be. It is there.
He's back.
What a joy. Record all the difficulties as the
Today, Judge, Mr. Mangolela is back on record.
As it pleases the court, my lord, we had a technological glitch that suspended my availability
I understand.
in court, and his lordship was asking
No
for,
problem, Mr. Mangolela.
as it pleases the court, my lord. His lordship, in
Yes.
points of limine advanced in the record of court, was his lordship's concern relative to my right of appearance in record of court, and then that particular right has been responded by directing the court to item number 20 in the index, that is at page 48 to page 52 on record of court, headed confirmatory affidavit, in which the natural person running the juristic person, Benja Enterprise, as the plaintiff, has duly confirmed my appearance and the right thereto in the applicable terms advanced in the confirmatory affidavit, my lord. So his lordship, having read the papers of record, would have understood that the reality of his lordship that he needs to take into account is the applicable terms at section 9 of the Constitution, obligating everyone to be equal before the law, and the applicable terms at section 34 of the Constitution, obligating a court or any person to bring a dispute that can be resolved by the application of law. And his lordship may not only subject himself to the applicable terms at section 22 of the Constitution, giving right or giving rise to the Legal Practice Act that regulates the legal practicing body in our republic. The Constitution, the court has to take into account that as much as there is a Legal Practice Act being enforced to the legal practitioners, there is indeed a Defense Act being enforced to members of the defense force and all other people in the republic, to provide for the defense of the republic and other matters connected thereto. This is one of those other matters that are connected to in the provision of the applicable terms at Chapter 11, delineating security services. I don't want to dwell into the applicable terms of the chapter. His Lordship is erudite in that particular regard. The whole reality is that...
Mr. Mangole?
Yes, my lord.
Mr. Mangole? Yes. I hear you. You are very eloquent.
My lord.
Again, I will ask, do you have the right of appearance in the High Court?
Correct, my lord. I do have the right of appearance in any other court in the Republic.
Okay, and in terms of what? In terms of the confirmatory affidavit?
In terms of the confirmatory affidavit, my lord.
Okay, and so that gives you the right of appearance in the High Court?
My lord, the right of appearance in any other court, including the High Court, is inherent, as I have explicitly set it out in terms of Section 3 of the Constitution first and Section 200 of the Constitution. And His Lordship would understand that any right, regardless of who is protecting or defending or representing that particular right, such person will land at the applicable terms that are on record of court right now relative to Section 38 and the enforcement of the rights in the Bill of Rights, my lord. And it is well understood that the issue that one does not have...
Mr. Mangole.
My lord.
Mr. Mangole, I enjoy listening to you.
Correct, my lord.
But we have to do things properly.
Correct, my lord.
Let's park the issue of your right of appearance for now. What is this matter all about?
The matter is...
Is this an appeal?
The matter...
In terms of, as you said last night, Section
18.
So Rule 49:18.
Yes, and Section 18 of the Superior Courts Act, my lord.
Okay, so is it an appeal?
There is indeed a judgment on the matter, my lord, that needs to be set aside, and then that particular judgment, my lord, can only be set aside when an appeal is lodged, as it is lodged.
Now, I want you to confirm, is it an appeal or not an appeal?
It is an urgent appeal, my lord.
It's an urgent appeal. Where is your application for leave to appeal and the judgment thereof?
The judgment thereof would be on record of court, on file, my lord, as recorded by the court a quo, and that giving rise to the second prayer on record before His Lordship now in terms of Rule 49:18, my lord. The reality of the averments advanced in that particular record or court or judgment.
Mr. Mangole.
Yes, my lord.
Where is the order that is granting you leave to appeal?
My lord, as I have said, and then I will not dilly-dally, we were on court, an order was made, we are in court now, praying for that particular order to be set aside. Inherently,
And what was that order that was made then?
the order that was made, my lord, is that the matter be re-enrolled by a person with LLB, and that I do not have any locus standi to bring any matter into a court, and then that this particular matter be disposed of by a person with an LLB qualification. And that order, it issued in terms of Section 165 of 5 of the Constitution.
Where is that order in your papers?
In my papers, my lord, the order is not present as a result of the inefficiencies of the typist and the court practices inherently leading to me not having a copy of that order, which I can show the Honorable Court as the copy of this other order, and then as I would show the Honorable Court, a copy of this other order. So it is inherently written on the court file before the record of court regarding this particular matter, my lord. And if his lordship would want to...
Mangole, you appear someone who knows the rules, who knows the law, who knows the procedures. That's how you appear.
Because that is the reality, my lord. I know all rules of all courts, including the International Criminal Court, my lord. It is that reality. I know what I am talking about. I am not finding it, or I am not in want of that particular reality, my lord.
Wonderful. Then you should know that in your papers, when you lodge an appeal, you should have a copy of the order that you want the court to set aside, as you say.
As I have already said on record, my lord, every effort was made to get the order, and then whatever...
In that case, Mr. Mangole, your matter is not ripe to be heard, because I need to see that order that you want me to set aside. What order will I say I'm setting aside?
Which, if I may ask the Honorable Court to stand down, and then we request the registrar of the court to ensure that the typist function accordingly, and then to make available that particular order for the court to set aside. Because the problem of not bringing it on record is not inherently to the plaintiff, but inherent to the court practices and its procedures that inhibited whatever that brings the matter to be urgent as it is, my lord. For we have done...
You will agree with me that I cannot set aside an order that I have not seen.
That is why I ask his lordship, as a person that has sworn an oath in terms of schedule item 6 in schedule 2 of the Constitution, my lord, to be faithful to the Republic, that it is not the plaintiff's fault that made sure that the order is not available before his lordship. And then let us tackle the problem in accordance with its merits and with its stance. And to resolve that particular problem now inherently would be
Mr. Mawale, I have heard that part. I don't want us to repeat ourselves.
Correct.
Now, what you have just explained, where do I find it in the papers?
As I have...
Because I'm sure, as you say, you know all the rules.
Correct, my
so
lord.
You will know that I cannot take evidence from the bar.
Correct,
you
my
are
lord.
representing, and you are not here to give evidence. You have not been sworn in, so you are not a witness.
My
so
lord,
what you just told me, where do I find it in the papers?
may I ask the court to stand down so that I can engage with the registrar to make the court order available for the record of court? For the court orders on them...
Before we do that, why is this matter urgent?
The urgency of the matter, my lord, is explicitly set out on the accompanying affidavit of on record of court at page 36 to page 40, and in particular at paragraph 4 of that.
Let me go there. Allow me time to go there.
As it pleases the court, my lord.
Noting that we've got two issues outstanding, your right of appearance and the court order. You say that I will find this in page 36?
Yes, my lord, to page 40. And in particular at page 37, paragraph 4, explicitly setting out the circumstances which renders the matter urgent and could not be heard in the later court.
I'm at paragraph 37, I'm at page 37, there is no paragraph 4.
There should be paragraph 4 just under sub paragraph 3.5, my lord. And then page 38 takes further the amendments advanced at paragraph 4 until.
Are you referring to the paragraph that is titled Departure from the Normal Course of Action or Agency?
Yes, my lord.
Okay, so is that what
renders the matter agent?
Explains agency.
Correct, my lord.
Okay. And when did the clock start ticking here for us to consider agency?
Okay, the clock started ticking with his lordship considering agency now, and I mean now, in terms of Article 6 of the Code of Judicial Conduct for all judges at all times, also in extrajudicial conduct, to comply with the law. Now, that is that agency, and then you go exactly as it is written on the amendments advanced relative to the notice in terms of Rule 49.18, explicitly setting out the requirements of or the obligations imposed in terms of Section 237 of the Constitution.
Mr. Mangola?
Yes, my lord.
Mr. Mangola, am I pronouncing your name correctly?
My lord, regarding my title is Lieutenant Commander, and let me correct his lordship in terms of Section 83 of the Constitution and the law at Section 54.3a of the Constitution, of the Defense Act, giving rise to the authority of the President to be the only person who may actually call me Mr. Mangolele. After he has called me, why I must not renounce my permanent commission to a rank of Lieutenant Commander, my lord. His lordship would understand that it would be improper for me as a learned person on record of court to refer to his lordship as Mr., because that on its own would be undermining the authority of his lordship on record of court, my lord. So I am very sensitive to the reality of being called Mr. while his lordship is...
Can you hold on one sec for me, please?
As it pleases the court, my lord.
Thank you. Okay. Technology almost escaped.
I understand. It plays with the best of us all the time. However, we are here to comply with its intermittent requirements at all times, my lord.
Now tell me, does this application meet the requirements of Rule 612?
The application meets the requirements of Rule 612, my lord, in particular what we have just alluded to at paragraph 4 at page 37, my lord, that explicitly abiding by the requirements of Rule 612b, requiring the plaintiff to explicitly set out the circumstances that renders the matter urgent, my lord. And the court's duty in that regard is to first protect...
In what way does this application meet the requirements of 612?
In every way relative to the amendments advanced that the letter from Wolf Hire Pty Ltd attached on record of court marked as DPW9, available on page 41 to page 42 of the record of court, my lord. That is the threat that the plaintiff's right in terms of section 22 that needs to be protected is infringed. And what has happened to this day is that we have approached...
Mr. Mamole, are you giving me evidence?
Correct, my lord. If I may give his lordship the evidence in terms for the record of court, because I give evidence as I allude to this matter with absolute trust that his lordship has read all the papers. And I mean not to misunderstand the meaning of the term reading the papers and understanding thereof before his lordship makes an order. That is why I...
Mr. Mamole. Mr. Mamole.
My lord.
You papers from page 36 to page
40.
40. That is where I will find the justification for this matter to come before this urgent court.
Correct, my lord.
I have considered those papers and I have made a view based on what I see on the papers. And that view is that this matter lacks urgency. And that being the case, in addition to the other challenges that you have, one of them being that you do not have the right of appearance, the other one being that I do not have a copy of the court order that you want this court to consider, I am of the view that this court will not be able to entertain this matter. And therefore, this matter is struck off the roll. And because you are not a legal practitioner and you have no opposition, there will be no order as to costs. And so that is the order that this court is giving. And thank you very much, Mr. Mamole.
In view...
And so the court... Sorry, Mr. Mamole.
In view of the court's view, and in explicit view of the court's view, this matter, if the court has completely read the papers, it challenges that particular locus standi that says, I am not proper before court. And that particular... Yes, my lord. I'm just on
you knowing all the rules, you will know what you need to do once the court has given its order. Because now, what you are doing now will actually put you against the rules. And so the court has ordered. And I suggest that you respect that, because I see that you are a law-abiding citizen. And so the court has given its order, and there being no other matter on the roll, the court will adjourn.
Before the court adjourns, my lord, let me explicitly, after the court has given its ruling, appeal in terms of Rule 49.1 of the Uniform Rules of Court, which grants the appellant a right to immediately appeal against the court or the court order or the judgment thereof, my lord. And that is what one is currently sitting on. And then that particular reality, as I see that everybody has left the meeting, will be alluded to his lordship in terms of an email that will be sent to his registrar to re-enroll the matter in accordance with its terms. And when I say in accordance with its terms, it's where now the court has to respect, to protect, to promote, and to fulfill the obligations imposed at Section 38 of the Constitution. Because any other reason or any other view that the court may have would be to be running away from respecting, protecting, and fulfilling the rights at Section 38 of the Constitution. For the record of court, I will end it there, my lord. May it please the court, and as the court pleases.